My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Red flag laws, the next pre-divorce personal attack. We already know that orders of protection are misused in Missouri as preemptive strikes in a pending divorce or paternity case. Once the ex parte order is entered, the subject of the order must scramble to prove they are not the evil being the other party says they are. Yes, we understand that burden of proof does lie on the moving party. However, realistically, when it comes to an order of protection case, you have to be prepared to refute what they have to say and show evidence that you are not a dangerous party. Okay, so there's a reason it is a first move in many divorces. Okay, red flag laws are going to be used the same way. There are already reports out of states with red flag laws that they are being used in conjunction with ex parte orders of protection to attack the spouse just prior to filing divorce. This is a very serious concern. Now, according to Reason magazine, in Florida and Maryland, both of which enacted red flag laws soon after the Parkland shooting, initial orders which are issued before the respondent has a chance to respond are almost never denied. Those orders last up to 2 weeks in Florida and up to a week in Maryland, and they can be extended for up to 6 months in Maryland as well. Now, at the next stage, when the respondent finally gets a hearing, renewable orders lasting up to a year are issued 62% of the time in Maryland and 95% of the time in Florida. The difference in approval rates may have something to do with the fact that Florida allows the petitions to be filed only by law enforcement agencies, while Maryland opens the door to relatives, intimates, cohabitants, physicians, mental health specialists, and damn near anybody. It needs to be said that I understand what they're trying to do. We get that. But this is not the vehicle to get mental health treatment to people. If anything, it makes it more likely that those people in need of mental health treatment will suffer silently. Missouri is not going to pass a red flag law. We recently passed a constitutional amendment requiring courts to apply strict scrutiny to restriction of gun rights cases. Now, the Missouri Supreme Court gutted that amendment in a series of rulings that I believe were wrongfully decided. However, those rulings dealt with nonviolent felons possessing firearms. The applicability of strict scrutiny has not been taken up by the Missouri Supreme Court, and I think that it will require strict scrutiny be applied as a standard. However, the court may water down the definition of strict scrutiny, as it did in the previous cases that it decided. So a red flag law is unlikely to come to Missouri unless the feds pass one, and this poses an interesting constitutional question. If the feds pass a red flag law as part of 18 U.S.C. 922, will the petitioners have to file in federal court? And are the local police going to be obligated to follow a federal court order that conflicts with the state constitution? Gosh, I think the answer to both of those questions is going to be yes. However, Missouri sheriffs and police chiefs may disagree with that. And that also tees the issue up for the Missouri Attorney General to take the issue up in court. And then it becomes a federal preemption issue. Under the doctrine of preemption based on the supremacy clause, federal law prohibits state law, federal law preempts state law, even when the laws conflict. However, this would not be a conflict of laws only, but also a jurisdictional issue with the ability of federal judges to command local law enforcement to enforce federal law. And it would be a state constitution v. federal law or a 10th Amendment issue. Now, absolutely no one is interested in watching a long dissertation on conflict of laws or constitutional law, except for a very few lawyers, and we email that stuff between us anyway. So I'm going to limit this discussion to the simple expression of government rarely surrenders power, and the feds will win in the end. Let's take a look for a moment of the civil rights movement. Now, the feds brought in the National Guard. They federalized the National Guard, and they sent U.S. Marshals down. It wasn't local law enforcement that made sure those kids got into school. It was federal power. So I think that that same thing may apply, and the feds will win in the end. However, The last thing the federal government ever wants to do is try and nationalize the Missouri National Guard to confiscate firearms from people. That won't go over well, and I don't think the National Guard would do it. That said, red flag laws are a serious violation of constitutional rights, with the limited due process given that fundamental rights are involved. And that's something that we need to fight at every step of the process. Okay, please hit like and subscribe. Target that alert bell so you know when our next video is posted. Thank you for watching. And remember that your rights are only protected to the extent that you are aware of them, practice them, and defend them. Thanks for watching.